invitation. Very happy to be here. As Amanda mentioned earlier, I am Associate General Counsel at Florida State University. So I'm kind of the oddball of the group. I'm not in a firm. My primary responsibility is to license intellectual property out of the university for the benefit of the public. This can be licensed to an existing company or an FSU startup company. And so I also assist faculty with starting companies. A little bit into business law that I didn't want to get into at all, but such is life. So I won't get too much more into what I do because I'll save that for the panel. But since I'm a negotiator, I'll make a deal with you since it's right after lunch. If you keep me awake, I'll keep you awake because I just had lunch too, okay? So that's our first deal. And speaking of being the oddball of the group, I figured it was appropriate to talk about the quote-unquote oddball of the intellectual property group, different ways you can protect different types of intellectual property. This one being design, and the focus is on design patent. Through law school, even studying for the patent bar, design patents were hardly even mentioned as a footnote or a sidebar. How many folks have even heard of a design patent? Not bad, okay, well you're ahead of the curve, and hopefully I'll catch everybody back up and everybody will be ahead of the curve. So I'm going to go into what a design patent is, what it protects, sort of what it looks like. Give some examples, and I'll go a little bit into the policy because you'll be pleasantly surprised perhaps to see there really isn't too much policy behind a design patent. I'll go into a little bit of the tests for infringement, damages, and talk about where we can go from here. So what is a design patent? A design patent may be obtained for any new, original, and ornamental design for an article of manufacture. So what does that mean? Well, if there's anything you take away and take home today, is that it protects the non-utilitarian features of an article of manufacture. The utilitarian features are protected by the utility patent. Again, the word patents can be kind of broad. It's usually assumed that the person is referring to a utility patent. So you've got two different patents that you can protect two different features of an article of manufacture. So keep that in mind for your intellectual property protection toolbox, if you will. So this specifically may relate to the configuration or shape of an article, the surface ornamentation applied to an article, or the combination thereof. And we can get into a debate for hours and hours about ornamentation versus functionality. Say for the design of an automobile, you want to protect the design, the ornamental features of, say, a Corvette. Now, those might also have utilitarian features. That design might have been made with the idea that you want to improve the aerodynamics, especially for a race car. Now, can you have both the design and utility patent? That answer is yes. You're going to want the utility patent to protect the aerodynamic features of the vehicle. Now, say if you're an automobile manufacturer, you're probably not going to be in the business of making toy cars or model cars, but you might want to license that to someone, especially with something as iconic and popular as a Corvette. So that's something to also keep in mind. Now, a design patent, probably the biggest difference between a design patent and a utility patent, as far as the document itself goes, is that there are no claims. Earlier this morning, you saw some claims from Dr. Jervis's talk. The claims, more or less, are the pictures or the drawings of a design patent. Now, drawings are very important in utility patents, but they are basically the heart of a design patent. Each design patent does have one claim and one claim only. It's pretty uniform. The claim is the ornamental design of the blank, and you fill in the blank with the article of manufacture featured in the drawings. That's the single claim of a design patent. And you'll see some notable design patents, the most notable being the Statue of Liberty. Do you think that's really protecting the actual statue? Probably not. This was used to protect the articles of manufacture, little souvenirs, statuettes of the Statue of Liberty, which I believe were actually sold before it was constructed to pay for its construction. So a little bit of a history lesson there. Coca-Cola bottle, probably one of the more famous design patents. This begins the overlap, and here's another debate we can have for hours, of trade dress protection versus design patent protection. Trade dress is in that area of trademark law where you're protecting the brand, you're identifying the source of the good through the packaging what your product comes in this case, the Coca-Cola bottle. And the Apple iPhone, which we will go into plenty this afternoon. And to come back to that claim, Apple had very good patent attorneys and made that claim as broad as possible. Remember when I said fill in the blank? Do you think they put the smartphone device or a telephone or a cellular phone in that blank? No, they put an electronic device. Because we all know iPods, there are iPods that look like that. Heck, even a tablet looks like that. So, very good protection from Apple, for Apple. Again, at FSU, my responsibility is to identify, protect, and license the university's intellectual property for the benefit of the public. Unfortunately, text transfer is not necessarily a money-making venture. We were fortunate enough to have a hit, and I'll talk about that a little bit later. But what do we consider a design patent? Here we have a cradle for an infant, and this is designed, that's the key word, because a cradle is known. A cradle is known in the art. What does it do? What is the utilitarian feature? Well, it holds an infant. But what are we protecting here? So we can't protect the utilitarian feature, but we can protect the design. And here is an interesting story. We have on the left Sean Coyne, who is a technician at our National High Magnetic Field Laboratory. He's our go-to guy in the machine shop. And he took a furniture making class with one of our interior design alum. We have a fantastic interior design program at FSU. And they got together and they designed a cradle to be used in women's shelters because they visited the women's shelter in Tallahassee and wanted to figure out what their need was. And they noticed that there were a lot of mothers that would come in and their baby would stay in the car seat, that they brought them in, or they would put the infant on the cot or the bunk with them, and we all know how dangerous that is. So they came up with a design of a cradle that already holds the infant, but this design allows the cradle, the infant, to sleep above the parent without the danger of the parent, say, rolling over or suffocating the child. And here's the actual figure from the design patent. And I have a video, if I can pop that up. Should work. Yes. So this will wake you up if you haven't fallen asleep already.
When we first came to the Hope Shelter, we saw bassinets and cradles and car seats being used as storage containers. And we interviewed some of the families and we took measurements of the rooms and the beds. And I think one of the important things that both Sean and I had to ask ourselves as parents was, would we use a bed that was where the baby was away from us? And we kind of both said no. In this tumultuous time, it's really important to have the baby close to you. You can't lock your door. You don't have privacy. You're at full capacity sharing a room with another family. So your natural instinct is going to want to be to have your baby close to you. And we really wanted to design something that allowed that, because otherwise it wouldn't get used.
We designed it, but Rochelle and I don't think we knew how important it was. It wasn't until we took it back there and Kay saw it, and she just this light bulb went off, and it made her very happy. And she was somebody right from the start who said, you've got to build this, you've got to do this. And having the people there also use it, and they kind of milled around and they put one of their infants in there, and just seeing that positive feedback. So it would be great to see it in use day to day. It's nice to see the cradle getting the recognition. We both, Rochelle and I both felt it was really something that was needed, and we had a lot of support from Kay Freeman right at the start of the project.
Everybody just really saw this and pushed us forward, and we couldn't have done it without, Sean and I are both so busy working and back then going to school, and we both had our families, that without this constant encouragement and nudging from FSU, we really wouldn't have been able to accomplish it.
Unfortunately, I can't take any credit for that nudging and encouragement, because this was before my time. But that's also part of my job.
When we first came to the Hope
Got it. So what else can be protected by a design patent? I just gave you one example at FSU, and I have to admit I'm cheating because that is our only example at FSU, but I'll talk more about that in a second. The most interesting thing that I learned is that you can protect graphical user interfaces. Does everybody know what a graphical user interface is? The icons on your phone, the way they're laid out, the way they're designed, in color, in shape. Novel fonts. This one's a little interesting. At first I didn't even realize you could patent novel fonts. I don't know why you would, unless you wanted to license it to someone else to use maybe in a trademark. At FSU, we have a trademark for our font that you see in our end zones. Yes, football is going to come up in this presentation. I'm sorry, but now it's over. I didn't put a picture, but we did a deal with Nike over the summer that we have our own font now. But other than that, you would file a font for a trademark. Perhaps, I believe folks still do that, not my area, but from what I know, most folks just file the basic word mark, which is just big black bold letters that will allow you to use any font. It's basically the word or phrase that gets the secondary meaning and identifies the source of goods or services. But just something to keep in mind, novel fonts and integrated circuit layouts. This one I kind of knew from studying for that pesky patent bar. Again, you know, integrated circuits, microchips, they're known, the utilitarian features, the materials, they're already covered. But what you do want to do is you want to incentivize folks to design more efficient circuits, and this is a way to protect that. So to come to an example of the graphical user interface, Apple was very savvy, once again, and here are 193 screenshots that were submitted to the United States Patent and Trademark Office for their graphical user interface for the iPhone. This was filed 6 days before the iPhones were sold in June 2007. Is this 193 design patents? No, this is one design patent. How much is it worth? You'll see in a bit. It's worth $725 million according to a verdict against Samsung. Not too shabby. You've heard a lot about FDA approval, fighting obviousness. I'm just uploading screenshots. That's what I'm doing if I'm Apple. Not too shabby, right? So where do patents kind of fit in? And there is a method to this madness. Design patents kind of suffer from that middle child syndrome, if you will, between the utility patent and the design patent, which I've kind of already gone into, but to just lay out the more specific features of each of these types of intellectual property. Utility patents, by definition, protect products, processes, machines, composition of matter, articles of manufacturer, and the term is 20 years from the date of filing. Again, this is the limited monopoly that you get for basically putting in the time, going through FDA approval, and spending the money to innovate. A design patent, again, protects the ornamental features of an article of manufacture. That term, not so long, but as you'll see, it's without the lag time in the patent office that was mentioned this morning, it could be pretty even Steven, so to speak. 14 years from the date of the grant, not from filing, but as you'll see, grant comes pretty quickly after filing. A trademark protects words, phrases, symbols, designs, or combination thereof, identifying and distinguishing the source of goods or services. So here you see article of manufacture up there in the utility patents, and then you see designs down here in trademark. So again, there's a debate we could have for hours and hours and hours, and this is just to illustrate where design patents sort of fit into your intellectual property toolbox. It's best if you have the money and resources to go ahead and protect as much as you can in as many different ways as you can. And I won't go into copyrights and trade secrets, just to save time. So what is the policy behind the design patent? I try to approach this like a first-year law student. This morning, it was pretty clear we have the innovation incentive from utility patents, and we have a consumer protection mechanism in our trademark law. It's to basically protect the consumer from having to do undue research. We take that burden off the consumer. It does also come back to protect the trademark holder because it's protecting the goodwill they build in that mark. But they have to do that. It's primarily a consumer protection mechanism. So design patents, it's kind of fill in the blank. And there's not a lot written on design patents because they're sort of kind of just lost and forgotten. So I've seen some folks fill in the blank with innovation incentive. Okay, I know it takes time, effort, and money, and a certain amount of expertise to create a design. That's true. Trademark consumer protection, especially if we're talking about trade dress, the Coca-Cola bottle, yes, I do agree. However, I don't know how design patents primarily protect consumers. I don't think that's the primary protection, especially as you'll see later, the rounded corners of a rectangular phone. I don't know if that's really something you're going to research or use to decide what kind of cell phone you're going to buy. So design patents by the numbers, I promise these are very simple numbers. You won't have to do any math. This is pretty basic, greater than or less than. So take a look at the number of utility patents that have been issued to date. As of January 1, 2014, the first utility patent that was issued was numbered 8 million, etc. Design patents, 696,000. Not a lot. This is why you don't hear a lot about design patents. I think you will soon, if you haven't already. And so those of you that didn't quit there when it comes to math, well, what does that mean? Is it harder to get design patents? Design patents came about 6 years after utility patents, so that's not it. So what happens? We have 81.6% of design patent applications are approved without any objection from the patent office. No rejection. Utility patents, that's something I would pay money for. And this is even more jaw-dropping. 98% of design patents eventually get approved, compared to 44% for utility patents. I'm going out and filing a utility patent right now. Let's go. Pendency at the USPTO, we're talking 3 to 5 years. These are my numbers based on what I see at FSU. Design patent, 3 to 6 months. Doesn't even compare. Not even close. For 14 years of protection versus 20, you're still getting a deal. You're getting an even bigger deal because the cost is 10%, so to speak. We're a small entity at FSU. Again, these are my numbers. We don't see $20,000 for a lot of our utility patents, but some in the bio area and the medical device area we do. But if you're a private company, these could get even higher. So you do the math. Not too hard, I promise. So who cares? Who cares about design patents? Well, just like utility patents, when the patent is issued, you get to put the patent number on the product, and you legally get to say this is a patented technology. This could be important if you're seeking investment. Even if you have an application in the works for those 3 to 6 months, you can legally say patent pending. This is a patent pending technology. Hopefully there are savvy investors that will do their due diligence, their homework, but maybe if you're a small startup at the angel investment phase, or your friends and family, you might get away with it. I wouldn't advise it, but so startup companies. When the economy tanked in 2008, word on the street was that this was the sort of workaround to get investors to invest in startup companies. I certainly don't advise it to our FSU startups. We don't want to lose the goodwill of our investors. That's not going to happen. But this is just to let you know that this was sort of the norm a few years ago. Hopefully it's not anymore. So who else cares about design patents? Okay, as an engineer, I'm going to buy a Dell, okay, because I wanted to, crunch the numbers. But a lot of folks don't care about that. They want something that looks cool. And here's that company again that's famous for design. That's what they built their brand on when they rebranded themselves in about the early 2000s. So large companies, established companies care about design patents, and it's no coincidence that Apple really cares. So before I go into infringement, I want to go a little bit into design patent validity, where it compares to utility patent validity, which we went into this morning. You heard about obviousness, and you heard about this person of ordinary skill in the art. So who is this person? I'm using Professor Bob Holton as an example because this was our big hit at FSU. Bob Holton invented what is known as Taxol. Taxol actually occurs in nature. It was found in a plant in the rainforest. So is that patentable subject matter? No. So what he did was he patented the synthesis method. Bristol-Myers Squibb scooped it up, and I believe they also worked with Bob to invent a new delivery method, a new drug delivery method. How much was that worth, though? $350 million to FSU, and a whole lot more to Bristol-Myers Squibb. So compare this with the design patent world, where obviousness is determined based on the I versus the knowledge, and this I belongs to an ordinary designer. What that is, I honestly can't tell you. A lot of folks like to confuse ordinary skill in the art and an ordinary designer, but as was mentioned this morning, this is a person of ordinary skill in chemistry, where a PhD is required. This is not an ordinary person, this is an ordinary chemist with a PhD in chemistry. So it's important to point that out before I talk about infringement. So what was the norm, what was the test for most of the tenure of the design patent? That is the point of novelty test, and I'll illustrate this when I talk about the Egyptian goddess case. But for now, we'll just look at the black letter law. The elements of infringement, the first being that the accused device is substantially similar, that's going to be very important, to the claimed design under what is referred to as the ordinary observer test. So here's another ordinary person. This is actually a whole different person. This is the jury. And the second element is that the accused device contains substantially the same points of novelty that distinguish the patented design from the prior art. Now, what is that point of novelty? Well, I'll get to that actually in the next slide. So the ordinary observer test, all you need to know here is that in Egyptian goddess, the Federal Circuit basically just took away that second point of novelty element. And it seems pretty simple. You take away an element, it must be easier to prove infringement. I don't think that's necessarily the case, but it is easier to prove infringement, and I'll illustrate that further than just taking away an element. So Egyptian goddess, what happened here? This was probably the biggest change to design patent law. This came down in 2008, where Egyptian goddess alleged that Suiza, I hope I'm saying that right, infringed on a design patent for a nail buffer. And I'll show you what that looks like in a second. So the Court of Appeals for the Federal Circuit, in an en banc unanimous opinion, that never happens. Never. So this was a big change. Everybody was paying attention to this. They reversed the district court summary judgment finding of non-infringement. So in Egyptian goddess, this is the nail buffer in question that was patented by Egyptian goddess. Have you seen the triangular nail buffers? I mean, first you have a nail buffer, it's naturally two-sided, so you have, a two-sided, so someone decided, well, let's make 3. So someone decided, well, they could have decided, let's make 4, but that's pretty utilitarian, right? We're in the design patent world. So now they just made a 3-padded buffer into a square. So what is the point of novelty? The point of novelty is this 4th side without a buffer. That's it. So it's important to point out this third person again that comes into the picture. You have the designer for validity. Well, in the design patent world, this would be the second person, but for illustrative purposes, what we're talking about today, the third person. So for infringement, this ordinary observer is actually acting as a purchaser. So this, I think, best illustrates how infringement is now easier to prove. You don't have to worry about this designer that has to point out a point of novelty, which is that 4th side without a pad. Now you can just hold up one buffer with the 4 sides and hold up the one with the 3 sides and say, is this the same product to the jury? So they said, no, this one's got a 4th side without a pad. So that actually shows it's not infringement. So is it easier? It's hard to tell. This is a little bit easier to tell. Apple versus Samsung. Has everybody heard of this case? Mm-hmm. I thought so. So I'll make it short. Apple alleged that Samsung infringed on the utility and design patents for a smartphone. So the jury found that Samsung infringed on the utility and design patents and awarded the $1.05 billion to Apple. $1.05 billion. And you hear the buzzword again, patents, 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 and people think, okay, yeah, that's beyond me, whatever. There were about 3 or 4 design patents in this case, one of them being for the graphical user interface that I showed you earlier. And it was later reduced, but there's going to be a retrial, so who knows, it could go back up to $1 billion, but that's just for your information. So let's take a look at one of the design patents in question. And this is the key to claiming, quote unquote, your design are the solid lines versus the dotted lines. So you're only claiming what is drawn in a solid line. Whatever is illustrated in a dotted line, you are not claiming. Do you think that's wise? Actually, it is. The dotted lines can be your friends. Notice here how the speaker, the home button, the entire back of the phone is not claimed. Have you noticed how the iPhone has evolved? The back's probably changed a heck of a lot more than the front. You still got that speaker and that home button? Do you think that's a coincidence? I don't. You could argue easily this covers, because this is definitely the first iPhone. If you look at the back, they're not claiming the back. Probably added a camera, but you don't have it here. Doesn't matter. So how does this compare with the Samsung Galaxy S4G? What do you think? In the Egyptian goddess case, before the test for infringement was changed, they actually had a jury construct claims. Because you have to put it into words, right, to explain it to a jury. So when they constructed a claim, quote unquote claim for the nail buffer, it was basically a 4-sided nail buffer having buffer pads on 3 sides with the 4th side without a pad. But the Federal Circuit didn't want to get into that claim construction. So again, without the point of novelty and without this claim construction, you just go in front of a jury, no technical background, don't even have to have design background. You hold up one handset, you hold up the other, and you say, is this the same? And they answer yes or no. And as Dr. Jervis even said, he heard that the attorney turned the lights down when they did this. So if you look at these two, now you've got infringement. If you were to construct claims for this, what would you say? Think about it that way. You have a rectangle with the screen and 4 rounded corners. How do we feel about that for public policy? That's probably going to have a chilling effect on design. Probably not going to have much of an effect on consumers. So why would you want to have a chilling effect on design? I mean, did you buy your cell phone because it has rounded corners? Probably not. Did you buy it because of the graphical user interface? Maybe, but the key to graphical user interfaces is that you're only infringing when it's fixed on a screen. Did you buy your phone fully charged, lit up, ready to go, or was it in the box not displaying anything? And back to the graphical user interface again, this is the actual graphic that Apple's attorney used for their graphical user interface patent. As you can see, they went into the various specifics. It's not just the screenshot. They submitted screenshots, but then they went a little further, say the rounded rectangle. So here's these 4 rounded corners again, now in an app icon instead of the handset. The mix of icon styles, color came into case here. My limited knowledge of design patterns, I never thought of color. But in this case, when you're submitting color screenshots, which you saw they were color screenshots, color can actually come into effect here. And the bottom row, which I think is the strongest case, personally. And I'll go a little bit into design patent damages. I don't want to go into math again. I promised you I wouldn't. But I have a quote here, because I couldn't have said it better myself, honestly. But when it comes to damages, most patent holders hope to recover a reasonable royalty, or maybe even their own lost profits. However, design patents hold out the prospect of another remedy. One utility patent holders can only dream of, and this is true, a recovery of the total profits made by the infringer. Design patents are looking pretty good now, aren't they? Not a lot of effort up front, very broad protection, especially for the graphical user interface, and even a handset with a screen and 4 rounded corners in a rectangular shape. So although design patents share many provisions of the patent statute with utility patents, they do not share all provisions. One provision that sets these two types of patents apart is 35 U.S.C. 289, which provides for the recovery of an infringer's total profits for design patent infringement. So that 1.05 billion is looking pretty good. So to sort of wrap up, what have we learned? And I put this in quotes. It's easy to obtain a design patent compared to a utility patent. Cheaper, faster, lower chance of rejection. And to be honest with you, a lot of potential infringers, they're probably aware of it now after Apple, Samsung, but in the past probably weren't really aware to look at prior art in the design world. But it is now, quote unquote, again, easier to prevail in an infringement action. I put that one in quotes because, like I said, in my opinion, if you remove that point of novelty test, which wasn't removed until Egyptian Goddess was appealed, point of novelty didn't really come into that, and it was still not infringement, but that's just my opinion. And you can recover total profits. So that's your take home for today. So who might care about design patents now? We have that lovely patent troll that might be coming back to haunt us in the design patent world. I got a lot of laughs, so I think everybody knows who a patent troll is. That's been in the news a lot lately, too. One thing that's come up recently are these patent consortiums, which I honestly don't know too much about, but this Rockstar Consortium is made up of Microsoft, Sony, Ericsson, Apple, I think there's 1 or 2 others that basically purchased the patents from the now defunct Nortel out of Canada, a telecommunications company. I did a quick check. There are some design patents in their portfolio, however, more for the old school wired telephone, if you will. Nothing cellular that I found. So what's happening? It's a little early to tell. Egyptian Goddess 2008, the economy tanked then, so I don't know if people were running to file design patents even though they were cheap and fast. Maybe they were. Startups certainly were. But the giants like Apple, I don't know. Well, they did for the phone, but other giants, let's put it that way. So this is hard to tell, and I don't think this has a pointer. But you can see a jump around 2005. Maybe that was Apple itself. I honestly don't know. You can see it dropped a little bit with the economy. I think that's reasonable and that's to be expected. And now it's gone up a little. 2010, 2011, some of these cases were making the news even if they weren't decided yet. So if I had to guess, I would say this is going to continue its upward trend as it is. I don't know if we're going to see another spike. So will the sleeping giant awaken? And here's the Guinness Book of World Records holder, at least at a certain time, for the tallest man. And he's Mr. Design Patent, and he's got his siblings with him, patent, trademark, copyright, or utility patent, trademark, copyright. There's trade secret, we'll call the last guy know how. I think it will. I think it will awaken. I don't know how much of a bubble it will be, but I think we will get into some sort of design patent reform. Again, this is my uneducated guess, well, slightly educated guess, if you will. So where will we go from here? Design patent reform, there's that troublesome word reform. We don't like change in the intellectual property community. The requirements, probably not. Probably not going to change. The infringement test, that's changed. Calculation of damages, I think that's the key. I think that's what you'll see. If you're recovering total profits from one aspect, and we're talking about a handset of a cellular phone, I mean, how much is that really worth compared to the processor, the antenna, etc.? But before we go anywhere, we've got to choose a theory. We've got to choose a policy. I don't see how we can get out of that. So where do we go from there? How do we choose a policy? Could we just stick with the innovation incentive? I think I discussed this earlier. Consumer protection, that's part of it. I don't think that's a good standalone theory. Combine them both. Something new. I know this isn't very creative, but maybe we can call it the design incentive. Again, I am not a designer, but I do know it takes time and effort. So we will come up with something. It's hard to articulate the design incentive just on the fly, but we can find a way, I think, to protect the consumer and the designer. This might actually have an innovation incentive in the utility patent world, because if you weren't already motivated to come up with something new, now you really are, because you want to jump on the design like Apple. I mean, smartphones weren't really around in 2007. At least you didn't really hear about them until the iPhone. There were a few, but they also came out in 2007. I think the closest thing would probably be the Palm Pilot. I might be dating myself here. Does anybody remember that? Your little personal organizer. I believe that also had rounded corners, but that's just me. I wouldn't want to put a product out there with sharp corners that could hurt people. I think that's more of a product liability thing than a design thing, but that's just me. But I think this would be a good topic to research for those of you on the law review, something to go into. Not a lot out there on this. And if you can help choose a theory, more power to you, because even I can't. So if we have time, I'd love to take questions. Yes?
There's a seeming overlap between, design patent and copyright trademark. If you're getting double protection, for example, for the graphic interface, right?
Mm-hmm.
You're going to get double protection, but the underlying technology is the source code to the graphic design, right? And that is copyrightable.
Yes.
So you're getting double protection, but now you're getting statutory damages from the design patent. Is that kind of what you're saying? Is it's going to get ridiculous?
I think it could. If it hasn't already, this happened.
The system is in place for that to happen.
I don't think copyrights were involved in this case.
But I mean, application programming interface, the source code is copyrightable.
Oh yeah, we
That's the
copyright all
underlying
ours.
information for graphic design of tech.
Right.
So where does it end?
Exactly. That's right. That's where you come in.
You emphasize that it's the still design pictures or drawings that are the crucial aspect. But how or could you go about getting a design patent for like the way the phones you can drag and drop, or you can pinch to zoom and point and click, things like that, things that are mobile and affect the design and the functionality of the interface, but you can't depict that on a still drawing. So would it be possible to get a design patent for something like that?
I'm not sure, but you can get protection. I don't remember if this was utility or design. I don't know how you would protect it in design, but Apple actually also received damages from Samsung for the bounce back effect. When you come to the end, okay, that makes more sense, because I couldn't see how you could cover that with design patent. That's an excellent question.
Has it spurred any ideas with our inventors? Do you think you have any design patents undiscovered? Any questions?
I think we've got one more.
Are there other ramifications outside of the tech world?
For design patents?
Yeah, like
That's a good question. Fashion, design, that is not my area, so I will not comment. I would definitely punt on that one. But fashion and design, yes.
I mean the same type of ramifications where you can have double protection.
Oh, absolutely. In fashion design, that you're designing a handbag, but is that also part of your trade dress, quote unquote, your Louis Vuittons, your Coaches?
And you're still entitled to the statutory damages of the design patent for a purpose.
I don't see why not, unless anybody knows the contrary, because I'm not the litigator.
So in the Apple Samsung slide you showed that the prosecutor used, one of the things was have a colorful icon. Did that actually help this case at all? Because I mean, that mean that like Samsung used grayscale icons that would somehow be different enough to help out?
Grayscale, you have the best bet of saying it's different enough.
It just seems strange that, like, who are you really protecting by saying only one company can have colorful icons? I mean, any company's going to use colorful icons because that's what consumers like.
Oh, absolutely. It wasn't the color itself. It's here, you see the phone icon, they're both green. Maybe if they used a red one, they could still use color, but they wouldn't be using green, which would be infringing. And I don't think it was infringing alone. I think it was this combination because you have the texting, you have the SMS messaging, that's the same color, green. You have the clock, that's gray/black. You have the World Wide Web, which is a different logo, but it's the same color again. I think it was a combination of those factors. Everybody awake? Good, I upheld my end of the deal. So did you.
Thank you, Abby.